If DHR has shown up at your front door, you probably want to know, what are my rights as a parent? You probably want to know, do I have to take a drug test? Do I have to let them in my house? The truth is, you don't have to let DHR in your house. The truth is, you're not required to take a drug test. But a lot of times, things come down to a practical effect of, do I have to do something versus should I do something? And so you have a right as a parent to stand up for your children. You have a right to make sure that DHR doesn't come into your house if you don't want them to come into your house. However, sometimes if you really get down to the nitty-gritty of what we're dealing with, many parents find it easier to talk with DHR, because if you don't, and DHR has reasonable suspicion to think that something has gone on in your home or in your life that is in danger of the children, they would more than likely try to talk to you at first, sometimes bully you, but try to talk to you at first and see if you would consider entering into what's called a safety plan. That's where you as a parent get to decide where your children are going to stay while an investigation goes on in your family. If you're not willing to do that, they may actually file a request with the court for the DHR to get a temporary emergency custody order, subject to a hearing that'll happen about within the next 3 days, a 72-hour or a probable cause or a shelter care hearing. And as you get to those, then your rights as a parent are preeminent, because we need to make sure that the court has to find that there's probable cause, which means a reasonable suspicion that you have done something to take the children out of your custody on an emergency basis. You have a right to stand up for your children. You have a right to make sure that your side of the story is heard. And sometimes talking to DHR is the best. But sometimes you need to make sure that you record the conversations. You've got a right to do that. You need to make sure that you ask them to put things in writing for you. You have a right to do that. As a parent, you need to make sure that you get the details from the worker or from the investigator of what's going on and what the allegations are against you, so you know how to respond. Most importantly, you should reach out to a lawyer who handles DHR cases every day all over Alabama and knows their policies better than those workers do. And we are proud to represent parents across the state of Alabama, and we've helped countless parents have the children returned to them, sometimes in the safety plan phase. Sometimes we fight it out over the long term through a DHR custody battle in the juvenile court. Wherever you are in that phase, you need an experienced representative who knows how to fight for you and your rights as a parent as you seek to protect your children's best interests. When DHR is involved in your life, you probably want to know, how do I handle DHR's involvement? Well, there's several things to keep in mind. The first thing you got to keep in mind is you should document everything. So many times, a DHR case may have 2 or 4 or 10 workers in a case over the course of the case. It's going to be an investigator. It's going to be a supervisor. It's going to be an ongoing worker. It's going to be their supervisor. Sometimes it's a foster care worker. Sometimes it's a family preservation officer. There are all kinds of people who may play into the case, and they may all tell you different things, and they're all a representative of the same department. And so you've got to make sure you document what's going on with DHR and what they've told you have to do. One of the ways I describe it so many times is that DHR will move the goalposts on you. They'll take your kids, or they'll have them in a safety plan, and they'll tell you, well, look, this is our concern. You need to do A, B, and C in order to get your children back. Well, what do? You cooperate. You do A, B, and C. And then a new worker comes in and says, well, that's good, but I also want you to do D, E, and F. And the list gets longer and longer. That is not okay. Unless new issues are coming up that you have to address on an emergency basis, or because some new problem has occurred, if DHR tells you, do these things to get your children back, I expect DHR to keep their word. They expect you to keep your word. And so when they have told you, do these things, you need to have documentation of what the worker told you. If they told you, you need to drug test on this schedule, and now they're saying, well, we wanted to do on this schedule. If you have documentation, that will help your attorney be able to show what DHR required of you and convince a judge that DHR has failed your family and they've refused to work with you on a reasonable basis. DHR has to provide what they call reasonable efforts to reunite the family. And we need to make sure that things are documented. So we don't want them to move the goalpost on you, but also, unfortunately, there are some workers that will decide from the moment they meet you what they want to happen to your case. And there's nothing you can tell them. There's nothing that you can do that's ever going to convince them to change their mind, because they already have formed an opinion about you that may or may not be fair. But as long as you do what you're required to do, and as long as you stay clean, as long as you get stable housing, as long as you have a clean home, as long as you're able to take care of all of the children's needs, they should not be able to keep your children away from you. And if we are able to show that DHR has failed to be honest with you, that they've moved the goalposts on you, that they have not provided reasonable services to your family, you may be successful more quickly than not in getting the children returned into your home. And so as you look at what all I need to do as I navigate a DHR situation, first of all, you need the appropriate help. Second of all, you need to document everything with DHR. And the third thing I would say is you need to make sure that you follow through on your word. You're probably going to have to work what's called services. That's certain things DHR wants you to do. Maybe it's counseling. Maybe it's random drug screens. Maybe it's taking a psychological evaluation. Certain things that they're going to ask you to do. You need to make sure that not only do you do those, but also that you get them done in as quick a time as possible, which leads me to this fourth thing that's very important. You need to make sure when you have a DHR case that you push DHR not just to do what they say to do it, but to do it in a timely fashion. So many times a parent may be asked to start random drug screens, and they're going to wait on the worker to set up what they call the purchase order or send out that invoice to the provider so they can start your random drug screens. And then that may take a month for them to do that. And then they're going to have you on such a low color that you may get only tested one time a month. And then here we are 4 months into the case, and you've had 2 or 3 drug screens. And then the DHR worker is going to say, yes, you're doing pretty good, but I need more drug tests to show you're staying clean. That's not your fault when DHR took a month to get it set up, and then they're only testing you one time a month. One of the things we often do in our office is we will just circumvent what DHR is doing, and we will go ahead and proactively put you on color code with a local agency where you can start to prove your sobriety, not on a once-a-month basis, but you can have frequent drug tests so we can show to the court that you on a random basis are being tested to show you are clean. And even if you failed a drug test initially, that's not a death knell for your case. We can work through that together, and as long as you're committed to being the parent you should be, we can make sure that when you hold DHR's feet to the fire, when you don't let them move the goalpost on you, when you document everything, when you work to make sure that you do services that you're asked to do, and you keep your end of the bargain, that your kids can come back home sooner rather than later. That's our goal, is to work with you to make sure that as a parent, you're able to provide a safe and stable home for your children, because nobody knows how to parent your children better than you do. That's why God gave you your children. It's because you could take care of them, not the state, not a grandparent. You could do that. And we'd love to help you get your children back home as soon as possible. When DHR opens an investigation with your family, eventually you're going to get a letter in the mail. If there's accusations against you, you're going to get a letter in the mail that says you're either indicated or not indicated for abuse or neglect of the children. It may be your children, it may be somebody else's children. But in DHR terminology, indicated means guilty. Not indicated means not guilty. And that means that more likely than not, that you did what they say you did, or you did not do what they say you did. If you get an indicated letter in the mail from DHR, you have a very short time period. We're talking 10 days to request an administrative record review, which basically means down in Montgomery, there's a panel of people at DHR in Montgomery who's going to review the case and see if there's a case file to back up that you should have in fact been indicated. Certain professions, whether it's teachers, social workers, healthcare providers, anyone who really is going to work with children, doesn't just have a right to have an administrative record review, but you also have a right to what's called an administrative law hearing, where you're going to go to an arbitrator who is basically a lawyer who works as a judge part-time, to have DHR have to prove their case to this arbitrator, just like they would in court, that they should be able to indicate you. Now, don't get confused. This doesn't mean you're criminally prosecuted. This doesn't mean that you won't have a DHR case in the court. We're talking about the indication, because a DHR indication can hang around and haunt you for a long time. If you have a custody battle come up in the future, you better believe they're going to look to see if you've ever been indicated by DHR. If you do get involved with DHR, they're going to look back to see if you've ever been involved with them before. So it's very, very important, if you are indicated by DHR for neglect or abuse, that you appeal that case. Now, that doesn't mean an appeal in the court. It could be an administrative record review, which you've got to request within 10 days. Or if you fall within certain professions, you may need to request this administrative law hearing and make sure that you are able to go to an arbitrator called an administrative law judge, and DHR has to prove their case about why they should indicate you. You'd be surprised at how often DHR does not keep great records. And when they don't, their file may be shoddy, or maybe the worker or the supervisor is no longer there, and they don't have anyone who can provide first-hand accounts to this administrative law judge about why you were indicated. And when you don't, we've seen many people have their DHR indications overturned, and that is what you want. At some point in your DHR case, the state may file a petition with the court alleging what's called dependency. Dependency just simply means that the child depends on somebody besides their mother or their dad to provide parental care for them. That's how DHR or a grandparent or a friend or anyone else gets custody of your children, is through this idea called dependency. So what if you have been involved with DHR and they file a case in your local juvenile court, and then you have a decision that doesn't work out for you, meaning someone else gets custody of your children, there are appeal options available. You can appeal. If there's not a good record, you can appeal to the circuit court for a new trial, or you may be able to appeal to the Court of Civil Appeals in Montgomery, where we ask the court to overturn the local juvenile court judge's decision to return the children to your care. There are all kinds of appeal options available. We've handled many of these for many years, and we'd love to help you make sure that you go to every length possible to regain custody of your children. When you're involved with DHR, you need an experienced and compassionate lawyer to listen to you and to fight for you and make sure that this brighter future that's on the horizon becomes a reality for your family. Reach out to us today. We look forward to helping you.